Welcome to Landmark Chambers webinar, the variation and enforcement of Section 106 obligations. We're delighted to see so many of you joining the session today, and we hope that you will find the presentations to be both useful and informative, as indeed the discussion at the end. My name is Graeme Keen, Queen's Counsel, and I will chair this session. And I'm joined by my colleagues Kate Olley, Matthew Henderson, and Nick Grant. And I will formally introduce them in a moment. But first, can we deal with a few matters of housekeeping? Your microphones are automatically muted, so you won't need to adjust your local settings. We welcome questions throughout the session. If you can please submit them via the text in the Q&A section at the bottom of your screens. Well, some of you will have them at the bottom, some of you at the top of your screen. And then we will endeavour to answer as many of those questions as we can at the end of the 4 presentations that we're going to have this morning. The webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. And finally, if your connection is lost at any point during this webinar, we invite you to rejoin the meeting by clicking on the original link once more. So let us begin. My fellow speakers are all barristers at Landmark Chambers. Kate Olley is a highly experienced planning law practitioner and public law specialist who practices both in the UK and internationally, particularly in Hong Kong. Matthew Henderson practices in planning, environmental, property and public law. He's ranked in Planning Magazine's top 20 juniors under 35 and has recently been appointed to the Attorney General's C panel of junior counsel. And Nick Grant practices in planning, commercial, compulsory purchase, property and public law, with particular interests in infrastructure, energy, housing and commercial services. The talks today are based on 5 papers written earlier in the summer by 3 of those on the webinar today, Nick, Kate and Matthew, as well as James Marici QC and Heather Sargent. All 5 papers are available on the Landmark website. In terms of our running order this morning, Kate will cover, first of all, ways to vary or discharge a Section 106 obligation. I will then discuss appeals in relation to variations and discharge. Matthew will then tell us about the relationship between Section 106 obligations and Section 73 of the Town and Country Planning Act, which of course is a topical issue in the light of the recent judgment of Mr. Justice Holgate in the Norfolk Holmes case. And then finally, last and certainly not least, Nick will deal with enforcement of planning obligations. So without any further ado, I'll hand over to Kate to take the first talk away. Thank you.
Well, thank you, Graeme, and good morning, everyone. It's my pleasure to start us off with the first talk. So let's look first at how to modify a Section 106 obligation before moving on to when and how that might be done. The mechanism is provided by Section 106A of the 1990 Act, which states that a planning obligation may not be modified or discharged except by either agreement between the appropriate authority and the person or persons against whom the obligation is enforceable, or in accordance with either Section 106A or Section 106B, effectively by application, with or without the need to appeal against the authority's decision on that. So there's always the possibility to renegotiate or agree a variation of a Section 106 obligation outside of the machinery provided by the 1990 Act, but there won't be any right of appeal in the case of an attempt to agree. Section 84 of the 1925 Act, I should just say, on discharging or modifying restrictive covenants affecting land expressly doesn't apply to Section 106s. So far, we don't have anything equivalent to Sections 106 B, A to C, which were enacted following the last financial crisis and which allowed for the modification or discharge of affordable housing requirements. So moving on to when a Section 106 can be modified, an agreement to modify or discharge can be made at any time, but has to be made by deed and will require the agreement of all the parties against whom the obligation is enforceable, which could be an issue. For example, if it's quite late in the development, perhaps the variation sought arguably doesn't affect persons who are nevertheless those against whom the obligation is enforceable. But after the expiry of the relevant period, which is 5 years beginning with the date the obligation was entered into, an application can be made to the appropriate authority, which, by the way, is the LPA, Mayor of London, or the Secretary of State, as the case may be. So when seeking a variation of a Section 106, the first consideration will be the age of the agreement. If 5 years has passed, an application can be made. The application process avoids the requirement for all parties to the Section 106 to sign a deed, which, as I've said, can be a problem even where the developer and LPA may agree on the terms. But there won't be any opportunity in the case of an application to place additional burdens on another party, subsection 5 there. The procedure that's set out in the Town and Country Planning Modification and Discharge Regulations 1992. These provide for the form and content of applications, publication of notice of them, a procedure for representations made about them, and for the notice of the decision. The application is made on a form provided by the LPA and requires the applicant's name and address, the address or location of the land to which the application relates and the applicant's interest in it, information to identify the obligation to be discharged, and the reasons for the application. It must be determined within 8 weeks of receipt, but it can be extended by agreement. What are the principles to be applied where an application is made? Section 106A6 provides 3 options for the authority on an application. Either it may decide that the obligation should continue to have effect without modification, or it could decide that the obligation no longer serves a useful purpose and shall be discharged, or it may decide that it does continue to serve a useful purpose, but that the purpose would be served equally well if the obligation had effect subject to the proposed modifications, and therefore that it shall do so. Mr. Justice Garnham in the Mansfield case looked at the correct approach, so let's have a look at that now. He looked at the decision of Mr. Justice Richards, as he then was in Garden and Leisure Group, and Richards J posed 4 questions. So 1, what is the current obligation? 2, what purpose does it fulfill? 3, is that a useful purpose? And 4, if so, would it be served equally well if it had effect subject to the proposed modifications? And Richards J had said that Section 106A involves a precise and specific statutory test and does not bring in the full range of planning considerations involved in, for example, an ordinary decision on the grant or refusal of planning permission. What about that useful purpose to be served by the planning obligation? The debate has been about whether it has to be a useful planning purpose. Sullivan J, as he then was in Bachelor Enterprises, said yes. Ousley J in Renaissance Habitat said no, or at least was less certain. Ousley was reluctant to narrow the range of public interest purposes that an obligation may be said to serve, although he did accept that the word planning was implied, given that the agreement could only be made in the first place for a planning purpose and could only be enforced by a public body acting for a public purpose under the Planning Acts. The problem was that despite the breadth of the word planning, it could nonetheless lead to a debate about what constitutes a planning consideration as opposed to some other useful public purpose or even a private purpose, such as the protection of private views, which might show the implied restriction to planning would be unjustified. Garnham J preferred the approach in Renaissance Habitat and gave 4 reasons for that. First, that the statute itself doesn't contain any qualification to the expression useful purpose. Secondly, that the planning encyclopedia didn't suggest any. Third, that the word planning invites debate about what constitutes a planning consideration in this context and therefore could lead to uncertainty. And fourthly, perhaps most importantly, there was no reason why, as a matter of principle, the precise character of the useful purpose served by the obligation should determine whether or not the authority had the power to discharge it. So the critical question is whether the obligation serves some useful function, the absence of which makes the maintenance of the obligation pointless. However, the bar is quite high on an application such as this, as the LPA would only have to credibly point to a useful subsisting purpose for the obligation. Thank you very much. That's the end of my talk, and I will now pass on to Graeme.
Okay, thank you very much, Kate. So I'm going to deal next with Section 106B appeals in relation to modifications and discharge of planning obligations. And I should say at the outset that these slides are based on a paper written by James Marici, Queen's Counsel, and the full paper is available on the Landmark website. So, first of all, I want to set out on this first slide parts of Section 106B. And again, the full section is in the paper for anyone who wants to study it in more detail. But by Section 106B1, where an authority other than the Secretary of State, A, failed to give notice, as mentioned in Section 106A7, or B, determined under Section 106A that a planning obligation shall continue to have effect without modification, the applicant may appeal to the Secretary of State. A couple of other points that I've drawn out there on the slide by subsection 7, it's worth noting that pursuant to Schedule 6 of the Town and Country Planning Act 1990, the determination of certain appeals by a person appointed by the Secretary of State applies to appeals under this section. And subsection 8, where the authority mentioned in subsection 1 is the Mayor of London, then references in Schedule 6 to the LPA are references to the Mayor. So some points to draw out from the statutory provision. Firstly, the right to invoke the Section 106A procedure, and thus the right to appeal under Section 106B, applies only where the planning obligation is at least 5 years old. An appeal under Section 106B is against a decision following an application made under Section 106A. And so where, therefore, an attempt is made to renegotiate and agree a modification or discharge outside of Section 106A, and this fails, there is no appeal, although, of course, the decision to refuse an application to modify or discharge would be amenable to judicial review. Third, there's no appeal under the where the application is under, there's no appeal where the application under Section 106A was to the Secretary of State in respect of a development consent obligation, as per Section 106C. And last point on this slide, an appeal may be made under this section against the refusal of the authority to modify or discharge an obligation under Section 106A, or their failure to issue notice of their decision within the prescribed 8-week period, unless there's been an agreed extension of that time. So in terms of non-determination, if the appeal has been submitted on the grounds of non-determination, it will be assumed that the authority has determined that the obligation will continue to have effect without modification. And although it's not an option formally recognised by the Act, it would still be open for the local authority to resolve in committee that if the application had still been before it, and pausing there, of course, once the application has been appealed to the Secretary of State, the authority no longer has locus standi to determine the application. But if the application had still been before it, then some form of partial modification might have been acceptable. And in that circumstance, it will be important for the authority to ensure that the Secretary of State and the appellant are informed promptly. And in that situation, an appellant could submit another application with amended modification, but I would suggest not want to withdraw the original appeal until the new application had been determined. Next, the jurisdiction then of the Secretary of State or the inspector. The jurisdiction on appeal is the same as that of the authority under Section 106A, subsection 4. And Kate mentioned this a few moments ago, but there are basically three options. A, the obligation shall continue to have effect without modification. B, the obligation no longer serves a useful purpose and may therefore be discharged. or C, that the obligation does continue to serve a useful purpose, but would still serve that purpose if it had effect subject to the mods specified in the application, and that it should therefore be modified in accordance with the application. Turning to timings and mode, any appeal must be made within 6 months of the date of the authority's decision or the expiry of the prescribed or agreed period, although the Secretary of State does have discretion to extend that period by virtue of Regulation 7 of the 1992 Modification and Discharge of Obligations Regulations. Section 106b(5) provides that either party may request to be heard before an inspector, and so PINS has a discretion in such circumstances as to whether to proceed by way of a hearing or an inquiry. But interestingly, unlike in Section 78 appeals, the appeal cannot proceed on the basis of written reps without the consent of both parties, and that's because Section 319A of the 1990 Act does not apply to Section 106B appeals. And I said there at the foot of the slide, in fact, though, written reps is a commonly agreed method of determination. It's actually the most common method of determination, followed by hearings, and then with only very few, or relatively few, appeals being determined by inquiry. And I think it's worth pausing there to say that whilst we can expect an increase in applications and indeed appeals for the variation and discharge of Section 106s, given the economic challenges we all now face, I wouldn't expect that pattern, that predominantly the appeals would be determined by written reps, to change as we move forward, not least because, of course, PINS has to, the inspectorate has to grapple with its caseload in the face of all these circumstances. Right, next, some formalities. Regulation 7.2 requires that an appeal under this section must be made on a form obtained from the Secretary of State. I provide the link on the slide, and it must include the information specified in the form. In addition, it has to be accompanied by a copy of the application, the certificate accompanying the application, the instrument by which the obligation was entered into, and that's the whole of the instrument, not just the relevant part of that instrument that may have been placed on public deposit by the authority. And lastly, any correspondence with the authority relating to the application, and if there is one, a notice of the decision. Appellants are required then to copy the completed notice of appeal to the authority when submitting it to the Secretary of State. Some miscellaneous points just to sweep up on this before we move on. None of the planning appeals rules and regulations apply to Section 106B appeals, but in practice, such hearings and inquiries are conducted along similar lines, and some Section 106B appeals are heard alongside other planning appeals. Jurisdiction to determine appeals under this section is transferred to inspectors under Regulation 8, but that's subject to the usual powers of the Secretary of State to recover jurisdiction under Schedule 6 of the 1990 Act, and indeed also under Schedule 6, an inspector has the same powers under this section as the Secretary of State. Last point on this slide, a decision made on appeal under Section 106B is amenable to judicial review. See the Mansfield decision, which Kate discussed a few moments ago in relation to 106A applications. All right, turning then to guidance and costs. Guidance can be dealt with very quickly because there's very limited PINS guidance on Section 106B appeals. For those of you interested, it won't take you long to read. There's the link. Turning to costs, as with other planning appeals, costs may be awarded for unreasonable behaviour. I provide the appeal reference to one such example for anyone who's interested. They can find out a little bit more about it, but essentially it was an appeal seeking to modify and delete financial obligations, which was dismissed, and costs were awarded against the appellant company who pursued an appeal that it was found to be directly contrary to judicial authority on Section 106A and B, and indeed who had been a party to one of the leading cases, the Renaissance Habitat case. Let's look next at some trends that we might be able to detect from appeals, having done a bit of a trawl. The most common appeal under Section 106B appears to be in relation to 106 obligations that restrict the occupancy of dwellings. So for example, holiday lets, agricultural workers, staff accommodation, affordable housing, and age restrictions on retirement flats, etc., or otherwise restrict the use of land. The appeals also contain many examples of developers seeking to argue that something they agreed to provide as part of obtaining permission is no longer necessary. And I'll give an example of an appeal which related to seeking to release a developer of a 530 house scheme from an obligation to provide a junior sports pitch. Recovery of a Section 106B appeal is a pretty rare beast. There's an example reference there, but that was where the 106B appeal was related to and indeed parasitic upon a Section 78 appeal that had been recovered. The success rate appears to be no better than about 50%. Perhaps that might be said to be unsurprising given the difficulty of meeting the applicable test that Kate's just explained of not serving a useful purpose. And it's also worth mentioning that the overall number of appeals is low, and that perhaps I would suggest reflects the fact that it's the stronger cases that are likely to be pursued on appeal. All right, and then in terms of what can we detect from 106B appeals that have actually made it to inquiry, and as I said earlier, there aren't so many of these relatively, but I've set out 5 examples on this slide and the next one, just to give us a brief flavour of the sort of things that are coming up at inquiry. The first was an appeal seeking modification of an obligation so as to increase the number of pupils on the roll of an independent school from 525 to 710 pupils, which was dismissed after 4 days at inquiry. The second was an appeal seeking to remove an area of land required to be maintained as a garden in a 106 obligation to allow the extension for a nursing home business, and that was dismissed after inquiry. The third, by way of contrast, is an example of an appeal allowed and costs awarded indeed to the appellant in that case, but that was one where the local authority withdrew its objection to a proposal to vary the terms of the obligation. And for anyone who's interested in reading a little bit more about that, there's more detail provided in the full paper behind this talk on the website. Fourth, discharge sort of obligations relating to education in a 315 home scheme. The obligations contained an option for land for a school, and if not, to exercise a financial contribution. It was argued there that any contribution would now be used not to meet need generated by the development, but to upgrade existing facilities. But again, the appeal was dismissed. You'll notice that most of those are fairly short one-day inquiries, with the exception of the first and the exception of the next example, the final one at inquiry that I'll give, which related to a Section 106B appeal linked to enforcement of planning appeals seeking discharge or modification of a 106 to allow the use of land for airport car parking. That was also dismissed, took a little longer, but as you can see there was a bit more to it than the argument over discharge or modification, because there were both planning appeals and enforcement appeals to deal with. So last slide for me before we move on to Matthew. I just pulled out a couple of court judgments in relation to 106B that are of perhaps some interest to some of you. First point, the fact that a sum has already been paid pursuant to a 106 obligation does not mean that 106A and an appeal under 106B are necessarily excluded. That's Patel and Brent. And see also, therefore, by analogy, York City Council and Trinity 1 Leeds, which was a 2018 Court of Appeal case dealing with Section 106BC appeals and whether this had retrospective effect. So although a developer was currently liable to pay an authority a sum of money in lieu of providing affordable housing under a 106 agreement, if the appeal against the refusal to modify the agreement by removing that obligation was successful, that would extinguish its liability to the authority. And I put there in brackets that you note, though, that 106BA to BC of the 1990 Act were repealed at the end of 2016, and that's because they were, as I'm sure many of you will know, provisions used to provide for an application and appeal procedure for the review of affordable housing obligations based on economic viability, but without having to take into account other aspects of the planning consent. And it was a measure introduced after the last financial crisis, but as Kate has already mentioned, no sign of a similar move yet by the government. So I think that brings me to the end of my slides, and I'll pass over to Matthew to tell us about section 73.
Thank you very much, Graeme. So my talk today deals with the interplay between section 73 and 106 of the 1990 Act. I'll run through some general principles on both of those provisions insofar as they're necessary. I'll then consider the relationship between them, and as Graeme mentioned at the start, also look at the recent judgment of Mr. Justice Holgate back in August of this year in the Norfolk Homes case, which dealt with both of these aspects in quite some detail. So starting then with section 73, what are the key characteristics for our purposes? Well, firstly, whilst they're commonly referred to as applications to amend or vary, this is technically inaccurate. The result, and this is the second bullet point, is that you have a new independent and freestanding permission. And in this respect, section 73 is distinct from section 96A. And it's an important consequence because it's the creation of that new independent and freestanding permission, which is one of the factors that often creates the confusion which occurs when you also have a section 106 agreement in the mix. And then picking up the third bullet point, as a result of having those independent and freestanding permissions, both your original section 70 permission, your subsequent section 73, or possibly multiple subsequent section 73 permissions, the developer will very often have a choice at that point. And that's the second factor which comes into the mix and which creates some of the difficulties in this area. And then finally, I've just touched on there, and I'll return to this point, that section 73 subsection 2 restricts the consideration of the local planning authority only to the question of conditions. But it's important to note that that's a question of conditions, and it's not a restriction in respect of whether or not a further planning obligation is required, or indeed whether a variation to an existing planning obligation is required. So turning then to section 106, insofar as we need to. First key point is that it runs with the land. Now that's often a contributory factor here, because you will get a developer that comes along subsequently will want to vary the scheme pursuant to section 73 to suit their own needs or wishes, but is nevertheless bound or potentially bound by the section 106 agreement, which was entered into by the original applicant, because that runs with the land. The second point, and again a key point, is it's a freestanding legal instrument, so it's no part of a planning permission. It must be said that it's very common that a 106 will be entered into immediately prior to the grant of planning permission, but it's not in any sense a link which is in the 1990 Act or elsewhere, and a 106 can be entered into entirely on its own terms. And then finally, and again importantly for the grey areas we're about to look at, section 106 subsection 2A allows for an obligation to be conditional, and it's that feature which gives the obligations the power to have the triggers. So for example, to trigger payment on commencement of development, to trigger the obligation becoming effective on the grant of permission, and so forth. So against that background, if we turn to put these together, the first key point is these are freestanding instruments with no statutory relationship. What that means is that insofar as there is a relationship between your grant of permission and your obligation, that relationship has to be in the express words of the obligation. The result being that when one comes to consider, is this obligation engaged when I'm dealing with this permission, it's essentially a question of interpretation to work out what the precise scope of that obligation may be. The absence of such a statutory mechanism is often what causes difficulties for two reasons. Firstly, because it leaves room for errors. That is to say, when the 106 is linked solely to the first permission and the local planning authority simply forget to vary it or to enter into a new obligation to cover the section 73 application. But secondly, it also gives scope on the developer's part, often for some dispute, depending on the scope of the link in the drafting, whether it's drafted tightly and by reference to a specific reference number of a planning permission, for example, or whether it's drafted more broadly and perhaps describes the development rather than referring to a particular planning application. But in general terms, if a local planning authority wants to link the section 73 application to the planning obligation, and by that I mean a planning obligation which has been entered into at the time of the first section 70 permission, there are two options. Either ensure that the original obligation has wording which is sufficiently broad to encompass subsequent applications. So, for example, a description of development which includes not only the first section 70 permission, but also includes words to the effect that any subsequent section 73 permission is captured. Or secondly, and indeed in any event, enter into a new obligation at the point of granting the section 73 application to ensure that everything which is needed for that development is secured. To take a common example, two planning permissions, the first by section 70, as at that time a section 106 agreement was entered into, and then a subsequent section 73 application, but no further section 106 agreement was entered into and there's no variation. I put some suggested questions here for both the local planning authorities and developers to consider and to work through. So the first question, which planning permission is being relied on? This is essentially a question of fact, and I refer back to the Robert Hitchens case that I put slightly earlier in the slides. So if the developer is progressing with development, well, under which permission? And that's, you have to be particularly careful where those permissions might be largely identical in terms of the development. Second question, was the obligation triggered by the development under the first permission? So for example, if you started development under the first permission, then switch to your section 73 permission, there may be the case for saying, well, actually the obligation has already been triggered by the works under that first permission. Particular care needs to be taken at this point to consider phased permissions. So for example, it may be that the trigger for, let's say, the affordable housing contribution for your first phase may have been satisfied, but triggers for later phases may not have been satisfied. And then the third question is, if the section 106 agreement hasn't been triggered either because of development under the first permission or development under the second permission, the question is, does the obligation encompass development under that later permission? So at that point, you stand back and you say, well, what is the link between my section 73 permission and my obligation? Is there such a link? What's the scope of that link? And at that point, you can often make a determination as to whether or not that obligation is still alive and in play. So to take an example of that, the Norfolk Homes case, by way of brief background, 2012 granted planning permission pursuant to section 70, and an obligation was entered into a matter of days before that. That obligation was expressly linked to the section 70 permission. It referred to the planning permission by its reference number, and it used the same description of the development. And that planning permission, and that planning obligation was conditional on two things. Firstly, the grant of planning permission, and secondly, the commencement of development. And for that purpose, development was only development under the 2012 permission. After that point, there was then a subsequent section 73 permission in 2013, and then a second section 73 permission in 2015. The issue which arose, and the developer brought this by way of a Part 8 claim seeking a declaration, was whether development under either of those later permissions, so either the 2013 permission or the 2015 permission, would have triggered the obligation in the planning obligation that was entered back into in 2012. The developer's position was quite simply that there was no such trigger, under the 2013 or 2015 permissions, because insofar as the obligation could be triggered, it should only be triggered by development under the 2012 permission, and they were relying not on the 2012 permission but on the freestanding 2015 permission. The local authority raised two arguments. The first, as a matter of interpretation, the obligation should be interpreted such that it applied to any subsequent Section 73 permission, and secondly, and alternatively, words should be implied into the description of the development in the obligation so that it referred to later Section 73 permissions rather than the words which were there on the page, so to speak, i.e. the reference number to the 2012 permission. On the first issue, that of interpretation, Mr. Justice Holgate rejected the local planning authority's arguments. In so doing, there's a very helpful and useful review of the authorities as to what the correct approach to the interpretation of a planning obligation should be. The conclusion of Mr. Justice Holgate was that there was no difference between the interpretation of a planning obligation and the interpretation of a planning permission. So the Trump and Lambeth line of authorities apply equally to a planning obligation as much as they do to a planning permission. And given that all of the usual principles of contractual interpretation apply, subject to considering the nature of a permission, or here a planning obligation, as a public document. And then on the second question, and perhaps the one that's most pertinent to my talk today, Mr. Justice Holgate rejected the argument that a term should be implied into the planning obligation to capture later Section 73 permissions. A few interesting points to raise here. Firstly, the court took a particularly stringent line, essentially on the merits, and whilst it was accepted by all parties that essentially there was no intention for the later permissions to be granted without an accompanying obligation, nevertheless, Mr. Justice Holgate didn't see that as being a good reason, essentially, to correct the error, to go back and to make the implication. And secondly, he rejected the argument that there was any sort of technical trap, by which I mean a trap that local planning authorities could unwittingly forget or omit or simply get the drafting wrong of the obligation, such that later permissions escaped having to make any contributions. His view was that as a freestanding mechanism, Section 106 was flexible in favour of both parties, flexible in favour of developers to tailor obligations to a scheme, but flexible also in respect of local planning authorities who, when they consider a Section 73 application, aren't bound by the original obligation, but instead can consider whether any new or different mitigation or contributions need to be sought at that point. And then the third and final reason for rejecting implication was that if a term was to be implied into the obligation such that any subsequent Section 73 application was caught, the consequence of that would be that if a Section 73 application was later made and something different was required in terms of contributions under the obligation, there would be a need to expressly disapply the original obligation and deal with it in that way. And he felt that that was inimical to the flexibility which he saw as being part and parcel of Section 106 agreements as freestanding instruments. So on both of those bases, the court found in favour of the developer and granted the declaration that permission, that the 2015 permission could be built out entirely without triggering any of the contributions which were required under the 2012 planning obligation. So with that, I will hand over to Nick.
Thank you, Matt. Excellent. Right, so assuming that your planning obligation has or hasn't been varied and hasn't been discharged, I'm now going to pick up on enforcement. Now, how you enforce one of these is primarily dictated by its nature, so we've got to start there, and the nature of a Section 106 agreement is primarily a contract. There are some statutory tweaks. The fact that it runs with the land, for example, is an exception to the rule of privity of contract, but it really much is contractual in its nature, and that's pretty much the starting point. And we get that re-emphasised in the Court of Appeal decision in Newham, LBC and Olley. Given that the basis is contractual, interpretation is primarily contractual, in the same way that Matt's just talked about, recently reviewed in Norfolk Holmes. And again, we've got the Hitchens decision as well. So against that contractual background, how do you enforce it? Well, there are a number of things to consider here. The first one is that the Section 106 is enforceable only by the LPA. Section 106.3 provides that an obligation is enforceable, and I quote, by the authority. The public, therefore, can't try and enforce it themselves, unsurprisingly. What has been an interesting attempt to get round this occurred in Milebush. There, a Section 106 agreement was made between Thameside MBC and London Borough of Hillingdon as LPA. Hillingdon, as the LPA, could require Thameside to grant a right of way over a service road. Milebush was seeking a declaration that the rights of way should be granted over both the service road and a pedestrian exit, and the Court of Appeal made abundantly clear that this was not appropriate for a third party to bring such proceedings, seeking a declaration on an S.106 agreement to which it was a stranger. So you have both statutory and contractual methods of enforcement, although there is, of course, some overlap. Section 106 itself provides for enforcement by injunctions, and I'll come back to that in more detail, by a self-help mechanism, where the obligation breached is to carry out operations in, on, under, or over land. The authority may enter the land and carry out the operations itself and recover expenses. And 106.12 provides that the Secretary of State may make regulations providing for the charging on land of any sums owed under the obligation or expenses incurred in the self-help remedy. But I checked fairly recently, and no regulations have been made under this section. Overlapping with these, because an S.106 is a contractual document, you have the ordinary contractual remedies. One of these is, of course, injunctions. So again, I'm going to come back to that. And this can also include standard money claims, and I'll come back to those slightly later and do them both in detail. What has been the case for quite some time now, and was clearly stated in the Avon CC case, is that a planning authority does not have to exhaust its planning enforcement remedies before it takes steps to enforce a Section 106. In that case, a landowner had given an obligation to the authority that if a mine owner agreed that if it did not by a certain date obtain planning permission to continue mining, it would cease to mine the land. The date passed, planning permission wasn't sought, they kept mining, and they argued that rather than go straight for an injunction under the section, well, it wasn't a Section 106 back then, but under the planning obligation, the local authority should have decided to try and enforce via planning, other planning mechanisms first. That was firmly rejected by the Court of Appeal. The point is, this is a contract. These are ordinary civil remedies for a contract, and so you're going to be stuck with them. And that's something that we see repeated time and time again in the jurisprudence. So, turning to injunctions. This is the main method of enforcement, and there are two cases that I think is worth going through. One is Newham, and the other is Oak Mesh. And between them, they come up with quite a lot of important points, particularly with arguments that we would see either commonly run or which developers in particular might well like to run. So Newham concerned a faith centre operating pursuant to a temporary planning permission which expired. The authority issued an enforcement notice requiring removal of faith centre, and the trustees of the trust that was operating said centre appealed. At the inquiry on appeal, the trust entered into a unilateral undertaking covenanting to submit within 12 months an application for a mixed-use development. The trust agreed in the unilateral undertaking that failing submission of the application, it would carry out removal works. The time came and went, no such application was made, and the trust then applied for a planning permission for a single faith-based use. This was refused, and the trust appealed again. The authority applied for an injunction requiring the trust to carry out the removal works specified in the undertaking, and refused to suspend the injunction. The matter got to the Court of Appeal, and this is where we get a lot of helpful guidance. There are 5 key points on which I would like to pick up. First, the majority of this decision concerns final injunctions. If you're looking at an interim injunction or hoping for an interim injunction, the American cyanide principles apply. Second, the Court of Appeal acknowledged that damages are rarely an adequate remedy for a breach of a planning obligation. It was common ground by that point that that is the case, but Lord Dyson continued and said explicitly that a local planning authority will rarely be able to point to a loss measurable in money terms that it has suffered as a result of such a breach. In seeking an injunction, it exercises a public function and does so in the public interest. Now, the strength of this argument may be thought to depend on the breach of the obligation in issue. So certainly so for an obligation to remove works. Maybe query whether this is as true for failure to build something. I think it is. And actually that's something that's dealt with in Oak Mesh, which I'll come back to. But you can see the argument that one might put, which is, we promised to build a school. Okay, here's the works for the school. Here's the money equivalent of the works for the school, sorry. I don't think that would run because the local authority, of course, has all its other public interest obligations, which revolve around creating this school, pupils, teachers, that sort of thing. But you can see, certainly in some cases, a temptation to try and go down that route. The third key point is that the Court of Appeal said that an injunction ought ordinarily to be granted. Here, the contractual context becomes particularly important. Dyson said that unless the local planning authority has been guilty of delay or unconscionable conduct, the type of thing that might justify a refusal of relief on ordinary equitable principles, the court will usually exercise its discretion to grant an injunction in a case of a substantial breach of a planning obligation. This applies whether the injunction is prohibitory or mandatory, because the court is doing no more than holding the party in breach to its bargain. And again, we see the fact that this is a contract reappearing. He makes the same point again slightly later in the judgment. Fourth, when looking at what matters the LPA should take into account, matters like, for example, that there's a planning appeal outstanding are usually irrelevant. The court, in that case, it was argued that the court's discretion should be exercised in the same way as it is for an application under section 187B, which is an injunction for breach of planning control, effectively broadly and taking into account, for example, those sorts of planning matters. The Court of Appeal rejected this too. There is a distinction drawn between matters that should be considered in the context of enforcement of planning control and other decisions, like whether to institute criminal proceedings or to enforce a contractual obligation. Section 106 is an obligation voluntarily given, and again, it's about holding someone to their bargain. If you want to vary that obligation, go through the channels that Kate, Graeme and Matthew have outlined earlier. Fifth, however, all of that concerns whether to grant an injunction. The court does have an inherent discretion after granting one to decide whether to suspend it. These are different questions. The grant of an injunction is said to reflect the court's view that a party should normally be held to its bargain. But there may be circumstances, said Lord Dyson, in which it is fair, just, and reasonable to suspend the injunction. Now, this should obviously be used sparingly, otherwise the planning purposes of a Section 106 agreement could be frustrated. But the court found that it was made out on the circumstances of this case. The planning appeal was likely to be determined before the end of the year, and if it succeeded, it would be very difficult for the council to continue reasonably to insist the trust comply with the undertaking. Requiring removal of the works would have caused the trust and the community considerable hardship. There was no particular planning detriment to allowing the status quo to continue, and a refusal to suspend would effectively preempt the outcome of the appeal. So taking all that into account, the injunction was made but suspended. So that's really quite helpful guidance, but the question then arises, what happens if the obligation, for example, is not to take something down, but is an obligation to build? We've seen in other areas, particularly construction law, that the courts they think it's generally inappropriate to order the performance of a building contract. Well, this point, among others, was firmly put in Oak Mesh. In that case, the Section 106 agreement provided that the developer would provide a pedestrian footpath link and bridge link to the site, obtaining approval in respect of method of construction, surfacing, etc., it was agreed that that would itself need planning permission. For various reasons, many years passed without that bridge being built. The land was transferred to another company who applied to discharge the obligation, and that application was refused. The local authority then brought an application for an injunction. Now, a number of arguments were put in that case, but I want to focus on 3. First, as I foreshadowed, it was argued that, like a construction case, the court shouldn't order or shouldn't enforce by injunction an obligation to build something, in this case, the bridge. The judge dismissed that argument. A Section 106 obligation to get something built is not comparable to a construction contract. Effectively, you look at what are the plans and what have you said you're going to build, and then you look at what's built and say, does this comply? There's no reason in that situation for the court to find itself doing things like supervising the works, adjudicating between the parties on what is or was not a reasonable performance of the obligation. The court only has to look at whether the result is achieved. Second, it was argued that as planning permission would be required for the bridge, a mandatory injunction should not be granted. Again, this was dismissed on the facts the court held that planning permission was highly likely to be granted, but in any case, if planning permission isn't granted, then you obviously in an injunction cannot require someone to do something that is illegal. So the builder would not be in breach if permission wasn't granted. Finally, the company argued that the LPA should just do the works itself using the powers of entry that I referred to earlier, and it made the point that the works now were going to be much more expensive. The judge dismissed both of those. The LPA in that case just didn't want to undertake those works. It's an LPA operating in a financially hostile environment. This was 2009, without the resources, skills or manpower to supervise construction and build a bridge. And the court said that was an entirely reasonable approach for them to take. And as to costs, the developer had the benefit of the Section 106 agreement. The increase in cost was largely due to the delay between the original developer and the new company in getting things done. So you couldn't get the benefit and then get out of it on the basis that it was going to be too expensive. And again, you wouldn't normally be able to get out of any sort of contract on the fact that it's now pricier than you thought it was when you agreed. So that's injunctions, and those are, as I said, the key areas, key points the key points to take away from that. Those are the primary methods of enforcing Section 106 agreements, but what about others? As for damages, they're available in theory, but as I discussed briefly earlier and has been repeatedly pointed out, it's difficult to see that they might be an adequate remedy. There's no reason an LPA can't claim them if it thinks it can adequately calculate them, but you're probably more likely to want something actually built. But if a Section 106 provides for a payment of a specific sum, then there's no reason why an LPA can't bring a debt claim. There's nothing stopping it as far as I can see, and in fact, I've seen a couple, although reported authorities on these are few and far between. If you're a developer on the receiving end of a debt claim, then again, you're looking really at ordinary contractual principles in which to try and get out of it. A couple of arguments I've seen. One run say that, for example, the S.106 is drafted in such a manner that the LPA must do something first before it's entitled to payment. Another is based on a condition having to be fulfilled that wasn't fulfilled. So interpretation arguments, a lot of them, but that's really what you're restricted to. What is clear is that you can't try resisting such claims on planning bases. This was something that was run in Renaissance, and actually we've seen Renaissance referred to by, I think it was by both Graeme and I think Matt. But that case, in that case, West Berks DC had issued a debt claim following Renaissance's failure to pay sums due under Section 106. Renaissance sought to JR that decision and brought new proceedings for that. The background was that the 106 had been agreed in 2005, after which the SPG, upon which the contributions had been calculated, were replaced and lower, meaning that had it been agreed later under a new SPG, lower contributions would have been due. It was argued, therefore, for the developer that the charges were unlawful as they were based on erroneous and unusual calculations, and that West Berks should not have brought the claim. So that was roundly rejected by Mr. Justice Ouseley for 4 reasons. First, the council was simply seeking to enforce its agreement, which was lawful when it was entered. The merits could have been contested before an inspector at the time, but they weren't, and nor were the statutory methods of variation or discharge used. The lawfulness of enforcement did not depend on the lawfulness of the calculations or methods, because it was only the sum that was put in the agreement. In any case, no challenge at the time had been brought to the lawfulness of the SPG. And in any case, as I said, the developer was simply being held to its agreement. The change in circumstances upon which that agreement was based did not make enforcement or the agreement itself unlawful. The court was not going to rewrite it for them. So again, a fairly unsympathetic approach, but one that's pretty much in line with what you'd expect in, frankly, ordinary contractual claims. I want to say a brief word before we move on to questions about ADR, because it is not uncommon for S.106s to contain ADR mechanisms. The most common one I've seen is expert determination. You sometimes get arbitration thrown in there too, but ED is the one that's normal. A review of all the law on expert determination and arbitration is obviously well beyond what we can do today, and I'm actually just going to make 4 points on ED because it's useful to know. First, expert determination is an inherently contractual process, and there have been statements by, I think, Lord Denning in the Campbell case that it's on your slide, that what underlies this is consent. Now, this raises the question whether if Section 106 is unilaterally imposed, so it's not a consensual agreement, it's a unilateral undertaking, the extent to which a local authority would be bound by an expert determination clause. Can't give you a definitive answer on that today, but it's an argument that I think would be interesting to run. Second point is that if the S.106 agreement provides for matters to be, or for dispute resolution to go to ED, or matters to be determined by ED, the courts will generally leave it to ED. Milebush is a pretty clear example of that. Recall that's the one where the third party was seeking declarations about the meaning of the Section 106 agreement and what rights should be granted thereunder. There was an ED clause in that, and without going into too much detail, there were references to the rights being granted as being sort of reasonable rights. And in the High Court, Mr. Justice Arnold said that the question of what was reasonable had to be determined by going through the dispute resolution clause. So although everything had now come to court, he could rule on the interpretation of the contract, but not methods of what would be reasonable in circumstances. That had to go to ED. The Court of Appeal upheld that. Third, it's possible to provide that expert determination can be final and binding, in which case you, of course, can't pursue a claim to a new tribunal claiming that the decision was wrong, but you can't totally oust the court's jurisdiction. So if there's been fraud or collusion, or what's known as a material departure from instructions, then you can get the court involved. Those are just some high-level points that I think are possibly the most relevant ones to S.106s, and that's pretty much it from me. So thank you all very much for listening. I'll hand back to Graeme.
Okay, thank you very much, Nick. That was terrific. Right, well, we'll turn some questions now. We've had quite a large number of questions, so we'll see what we can do in terms of getting through. And I think perhaps unsurprisingly, most are directed towards Kate and Matthew's talks. So Kate, should we start with you?
Yes.
Let's see now. If I've let's just get up the list. Let's just take some.
Should I pick out, Graeme, the ones that seem to be relevant to me?
Sorry?
Should I pick out the ones that seem to be relevant to my talk? Is that helpful?
Yeah, sure. I was going to start by asking you the very first question that we had, actually. So you get in early, it pays off. Under Section 106A, against whom is the obligation enforceable? Does it have to be the original parties or just those parties liable for the obligation they're seeking to modify?
Yes, okay. No, not necessarily the original parties. Literally those against whom the obligation is enforceable. I noticed that someone said it's usual practice to exclude liability under a Section 106 for plot purchases on a housing site. If the council doesn't agree to including this and the Section 106 needs to be varied by deed in the future, it's often impractical to get 200 or more homeowners to sign any deed of variation for Section 106. Indeed, So does this mean that any deed of variation in these circumstances would not be valid in law? Yes, I quite agree, but it will be fine where liability is expressly excluded for the plot purchases in the original agreement. So that's the important point there. I think someone's also asked about where one of the original signatories has applied to vary the section 106 within 5 years, and their clients object. Are the clients required to agree or sign a variation? No, they're not. So those seem to be questions in a group. I'll just deal with also. Does the LPA have discretion to accept an application earlier than the 5-year point? No, that would send you back into the agreement route rather than the application route. That's a fairly sort of bright line statutory rule. In terms of where the 5-year period runs from, is it from the date of the original section 106 or the date of a previous variation? My view is very much it's from the date of the original section 106. I think we'd see more words in the statutory provision if it was a sort of rolling 5-year period. So I've picked up quite a few questions there, Graeme. Sorry if that's
no, I think that's helpful. I'm just going to have a quick look at perhaps one more, Kate, before we move on. Yes. The question where the benefit of one of the obligations to be modified is for another organisation, for example, an educational authority. If a 106A application is made, what should the authority do? Or have consultation with the county or what to do with their comments?
Yes, so if there's an application made, obviously there is a procedure for seeking representations. So what should the LPA do by way of consultation? Well, the notice of the application will be publicised, and obviously it's in terms of the weight to be given, that's a matter for the authority, but would expect representation to be made in those circumstances.
Okay, all right. Let's then turn to Matthew. Let's pick up a few for you, Matthew, if I may. Question from one of our listeners: if I want to amend a condition via section 73 and a 106 needs to be amended as a consequence, must the revised 106 be submitted, or can we submit 106 heads of terms, get that agreed and sort out the wording of the 106 later?
So there's no need necessarily to submit your 106 in complete form, but this goes back really to the point about making sure that the local planning authority don't overlook that need for a 106, because there's, as I've said, there's no tie between 106 and 73 in the legislation. So in that circumstance, the 73 application could be determined entirely freestanding and without any consideration of the 106. Now, as a matter of reality here, it seems that the 106 is needed. And if the local authority are also of that view, then they need to ensure that 106 is in place before they grant the section 73 application. So going back to whether or not you need to submit it, well, no, you don't, but the reality is you're going to have to sort out the wording before you get your section 73 permission.
Yeah, okay. Let's find another. In a situation where section 73 application has been submitted and the authority's 106 requirements or policies have changed that result in additional contributions being required over the original 106, or in respect of a new requirement, is the local authority justified in seeking a variation of the 106 to capture additional contributions?
Yes, that goes back firstly to the fact that section 73, the material considerations are those that exist at the time of your determination of the application. So if things have changed, for example, in policy, then you're not stuck with what was in the original 106. And then, as was very clear in the Norfolk Homes case, your 106 is freestanding. It can be revisited by the party. So in that instance, then yes, absolutely, the LPA can revisit the 106 and require different or varied obligations and the contributions at that point to meet what are the current policy requirements.
Yeah, I suppose one thing that occurs to me, Matthew, is, I mean, the Norfolk Homes case shows us, if we needed to be told, that 106s should either be drafted to allow for subsequent section 73 permissions and ensure the obligation remains binding, or that before granting Section 73, the authority should consider whether an obligation needs to be varied and a new obligation entered into. But I mean, personally, I was quite surprised that Christopher Lockup Mummery QC's application for summary judgment didn't succeed, but the thing went the distance before Mr. Justice Holgate. But just really, I suppose, picking up on a number of questions that we've had on this point, where do you see real world consequences in the light of the Norfolk hearing and perhaps the need to dust off old 106s and have a look and see what's going on?
Yeah, I mean, firstly, I absolutely agree that I think the claimant was slightly unlucky, frankly, at the summary judgment stage, especially given the trenchant terms in which they ultimately obtained judgment and their declaration. I suppose in real world terms, then I don't think it's so much something which can be looked at retrospectively, because your scope to go back with a developer and ultimately achieve anything retrospectively is probably very narrow. It's more a case of ensuring as a local planning authority that your checklist when you come to determine a Section 73 application includes consideration of the 106 situation. Secondly, perhaps also thinking about if you use a standard template, ensuring that your standard template includes some words that wrap up and capture further matters. But conversely, if you're acting for a developer, well, you may well be wanting to dust off some of your old 106s to see quite what the scope of them is. But I don't think there's any sense that Norfolk Homes is new law. It simply reaffirms a lot of what's been done before, albeit deals with, I suppose, the new points that were raised by the local authority. And I suppose the reason why summary judgment wasn't granted was because they raised these new points about how far Lambeth, back from 2018, 2019, had an impact on the interpretation of planning obligations, but that's now settled. So there's nothing new there.
One question just in on that is that the end of the story, or is Norfolk being appealed to?
That's a good question. I'm not aware that it's been appealed. But I can't. I wouldn't say definitively. But so far as I'm aware, no.
All right. Let's see. No, I don't know. Is there anything you want to pick up, Matthew, before I?
No, I think I think we've covered quite a few points there, Graeme.
All right. Yeah, we don't keep everyone too long. All right, Nick. Let's start. There was a question early on for you that I thought would be a good one to pick up at the outset. With regard to open space and related obligations, would it be possible to provide for latent defects which may appear later on?
I don't see why not, but you're going to have to be careful about how you draft it. What you don't want to do is get into it effectively being like a construction contract, because that makes getting an injunction much trickier. Difficult to advise in the abstract, obviously, but you might want to be looking at how you're defining having delivered this particular infrastructure and taking into account, having fixed or saying that you've not been taken to deliver it if latent defects haven't been fixed within a year or 2 years or whatever you want to do. So in theory possible, but you've got to be careful on your drafting.
Okay. And let's see, find another one for you. Where were we? Well, could you mentioned towards the later end of your talk, the reference, you referred to material departure from the instructions for the purposes of expert determination, the Barclays Bank case. Can you request for a bit more information on what you mean by material departure from instructions in the context of expert determination?
Sure. I mean, as I said, the basis of an expert determination is contract and agreement and the instructions to the expert. So if, for example, the expert values the wrong shares or decides a question that's not been put to them, or sometimes misinterprets matters of principle, although again, then you get into the question of whether you can appeal on those points of principle or not. The way it's commonly put is if they answer the right question in the wrong way, you're stuck with it. If they answer the wrong question but do it in the right way, the decision is a nullity.
Another question for you. Are local authorities expected to apply broadly similar principles to 106 enforcement? as apply to enforcement of planning conditions? Is it
not so
expedient?
much look at Newham on that. That's basically what it's going through.
Okay. All right. Does any of you want to pick up anything further? I think we've covered quite a lot of the territory. Obviously, can't answer
There's
everything.
one. I've seen a couple of very short ones I'd like to pick up, if I may.
Sure.
One is, can an LPA, how does a local planning authority secure a Section 106 with itself? It can't. You can't contract with yourself, I'm afraid. The way round that is either you try and deal with if there's someone else involved and you're trying to grant, at least you might be able to do it that way, but it's complicated. Or if there are two tiers of local authority, you can make the other one the enforcing authority. But if you're a unitary authority, you can't. There's one that's asking if what needs to be in letters of instruction if council's being instructed as an expert or arbitrator. Difficult to advise in the abstract. It depends on pursuant to which rules they're being instructed. So RICS has different requirements of the Law Society, for example. So again, I'm afraid can't give a firm answer there. And the last one that I'd quite like to answer is whether damages could be an adequate remedy for failing to provide affordable housing. If you're the local authority and you think you can calculate it and you're fine with that being adequate, then that's really up to you. If you're a developer, I highly doubt you'll ever get that argument through over the objections of the local authority. Because again, you're not just dealing with bricks and mortar, particularly with affordable housing. How are you going to take into account and quantify the losses if, for example, they have to grant other planning permissions that they wouldn't have wanted to grant because their affordable housing quota is too low because you didn't comply with your obligation. So yeah, depends which side of the argument you're on for that one, I think.
Okay.
Just a couple more,
yeah,
Graeme.
okay, carry on.
I'll deal with.
Yeah.
So when a Section 106 variation is done by an application, do all parties need to join in the deed? They don't, but of course you also can't then impose a further obligation on a party that's not going to be involved. Is it ultra vires for the LPA to accept an application to vary a Section 106 if within the 5 years? And if outside the 5 years, are the LPA incorrect, also require a deed of variation? So within the 5 years, it has to be the agreement route rather than the application route. So an application where they would have to be treated as a request to agree. Outside the 5 years, are they incorrect, also require a deed of variation? I don't know whether you have any view on this, Graeme. If it goes to appeal, for example, then the decision letter will stand, or if it doesn't go to appeal, the LPA's decision notice will stand as the modifications. But if the modifications are quite complex, I don't see any difficulty with suggesting that deed is entered into, but I don't think the LPA could actually insist on that.
I think that's 106.8, isn't it? As I recall. Yeah,
absolutely.
Yeah.
Section 8. Thank you.
Thank you very much. Matthew, anything else before we?
I think we've covered a good number of points there, Graeme.
I think we have too, and I think we're probably keeping everyone from a well-earned drink before lunch. But so I think we'll draw stumps there. Thank you very much to Kate, to Matthew, and to Nick for excellent presentations, and thank you to you all, everyone who's joined us for listening. Thank you very much.